Ms. Attieh is also a lead forensic science instructor in forensic fusion. Ms. Attieh's commitment to enhancing her professional skills and contributing to her community has made her a valued expert in both emergency response and forensic investigations. Please join me in inviting Ms. Yoanna Attieh in our webinar. Thank you. Most welcome, Ms. Yoanna.
Okay, so hi everyone. It's an honor to speak to you today on the subject of public international law. A special thank to Mr. Swapnil, Mr. Hassan, and Forensic Fusion team for having me today. And kindly, I would like to thank each one of you for joining us today. And please, whenever you have any question, kindly leave them in the chat box. So I'll be answering them at the end of the webinar. Okay, are you able to see the slides? Can you hear me?
Yes, ma'am.
All right, so are you able to see the slides?
Yes, ma'am. Yes, ma'am.
All right.
Yes, ma'am.
So, okay. Okay. Now, are you able to see the definition and mission?
Yes, ma'am. Yes, ma'am. Yes, ma'am.
So let's get started. According to the modern definition, public international law is a set of legal rules that governs the interactions between states, international organizations, and individuals under certain specific circumstances, guys. This means that in cases of conflict between states, public international law provides a framework for resolving disputes. In addition to states, we have other actors that play an important role in international relations, such as international organizations and individuals in specific circumstances. Great examples about international organizations like the United Nations, the Interpol, the International Criminal Court, the WHO, the UNESCO, we have the European Union, and the European Court of Human Rights. I want you to know, guys, something very important, that international organizations are created by states and only states, not individuals. So this creation is through treaties, all right? Now, talking about the mission of international public law, we have several critical functions like regulation of international relations. This establishes norms and principles to govern relations among states, ensuring a degree of predictability and order. We have also the protection of fundamental human rights. So here, guys, this mandates respect for the inherent rights of individuals, contributing to the broader goal of global justice and equity. Moving forward, we have the facilitation of self-determination. I want you to know that public international law supports the right of peoples to determine their own political, economic, and social systems without any external interference. Now, moving up forward, we're going to cover the sources of public international law. So we have sources that are enumerated in Article 38 of the Statute of the ICJ, which is the International Court of Justice, and include international conventions, I mean treaties. So treaties, guys, are formal agreements between states governed by international law rather than domestic legal system. Okay, we have also the international customs. Here we have two types of international customs. We have the material customs and the moral customs. Talking about the material customs derived from the consistent repetition of specific legal practices, and the moral customs rooted in the acceptance and recognition of such practices by the international community. For example, the immunity of ambassadors. Also, we have the human treatment of prisoners of war and the prohibition of killing injured soldiers. Another source is the judicial decision. So the court rulings that serve as references for resolving similar legal disputes in the future. We have also the equity. The equity, guys, is the ability of courts to decide cases and provide legal solutions based on fairness and justice, particularly in situations where the rigid application of the law may fall short. We have also the doctrine. Talking about doctrine are the teachings from international lawyers or conferences or scholarly works and legal memoranda that offer clarity and interpretation in complex or ambiguous situations. We have also the general principle of law. So general principle of law, guys, are fundamental norms recognized universally. These principles ensure that international relations are guided by justice, fairness, and respect for sovereignty. For example, we have the principle of justice. They form the foundation of equitable decision-making and the fair treatment of all parties in international disputes. We have also the principles of maintenance of international peace and security. So these norms emphasize the prevention of conflicts and the promotion of global stability. Also, the principles of self-defense, so they recognize a state's inherent right to defend itself against aggression in line with international law. And we have the principle of non-intervention. This is very important here. These principles, guys, safeguard the sovereignty of states by prohibiting interference in domestic affairs. And we have the principle of good faith. So this principle emphasizes the importance of honesty and sincerity in international agreements and relations. Uh, of course, we have the principle of equality between states. They affirm that all states, regardless of size or power, possess equal legal standing under international law. So all the states are equal. And we have finally the prohibition of the use of force between states. So this principle prohibits aggression and emphasizes the importance of diplomacy and peaceful coexistence. Now we have sources beyond Article 38 of the ICJ statute. While these principles, guys, are not enumerated in Article 38 of the ICJ, they are undeniably vital to the development of international law. So a great example, okay, here is the unilateral judicial acts of state. So unilateral acts by states, when consistent and repeated over time, can significantly contribute to the formation of customary international law. And here we have a very great example, which is the Montego Bay Convention of 1982. So prior to its adoption, decades of consistent unilateral acts by states in maritime affairs played a decisive role in shaping customary norms in this domain. So these acts, rooted in state practice, demonstrate how unilateral expressions can crystallize into binding international law. So now another source are the resolutions of international organizations. So these resolutions adopted by bodies such as the United Nations play an indispensable role in clarifying and developing customary law. For example, we have the Security Council and the General Assembly resolutions. These resolutions provide guidance, reflect international consensus, and often shape the evolution of legal norms. Another one is the regional organizations. So similarly, resolutions adopted at the regional level contribute to addressing specific issues and fostering cooperation among neighboring states. Although, guys, these resolutions are omitted from Article 38 of the ICJ statute, their influence in shaping international law is undeniable, reflecting the dynamic and evolving nature of international legal system. So, Braf, the general principles of law and sources beyond Article 38 of the ICJ statute serve as indispensable pillars in the development and application of international law. Also, they ensure that justice, fairness, and peace prevail in global governance. As the world continues to face complex challenges, these principles, guys, and supplementary sources offer a robust framework for navigating legal and diplomatic complications. Now, okay, are you still able to see the slides?
Yes, ma'am.
All right. So now we will highlight the principle of voluntarism at the level of the Security Council and the ICJ. And this is one of the most challenges that the international public law faces. So as overview, we all know that the United Nations is composed of hundreds of states through an international treaty and has five principal organs. These principal organs are the General Assembly, the Security Council, the ECOSOC, known by the Economic and Social Council. We have the Secretariat, and finally the ICJ, which is the International Court of Justice. So I want you to know that in order for any country to join the United Nations, as per Article 4 of the United Nations Charter, two conditions must be present. First, the country should be peace-loving. And second, the country should accept the obligations of the United Nations. So the applicant state submits a request to the United Nations Secretary General, who then presents the request to the Security Council. And the Security Council reviews the application and makes a recommendation to the General Assembly by examining 5 key criteria for the applicant state. And these criteria are the applicant state must have a defined territory. must have a population. Also, this applicant state must have international recognition through diplomatic relations, sovereignty, which is the capacity to engage in international relations, and a government that exercises the exclusive power of compulsions, which means army. So, a great question here. Is the United Nations membership a condition for statehood? What do you think, guys? Let me rephrase. In order, if a state doesn't join the United Nations, is it still considered as a state? What do you think? Go ahead. Can you hear me?
Ma'am, can you repeat the question?
Sure. I was saying, is the United Nations membership a condition for statehood? In other words, if a state or a country doesn't join the United Nations, is it still considered as a state? Can you repeat? Well,
Yes, I think they said that yes, it is considered a state.
yes, absolutely. Simply because, for example, Switzerland was considered a state before joining the United Nations in 2000. So, guys, it's not a condition of statehood. Okay, the United Nations membership is not considered a condition of statehood. So, now, moving forward, we're going to highlight the main title of our topic for today, which is the challenges in public international law. So, as you know, guys, public international law faces substantial challenges, unlike domestic legal systems that have codified law. Because public international law, guys, is a collection of treaties or conventions and customs. So we do not have a certain code for public international law. However, it's a collection of treaties, conventions, and customs. So this lack of unified legal code creates inherent complexities. We're going to talk about the voluntarism or the principle of voluntarism. Uh, the principle of voluntarism, guys, operates in two key areas of international law, in the United Nations Security Council and the International Court of Justice. Because voluntarism highlights the sovereignty of states in international relations, emphasizing their discretion in decision making and participations. So, moving forward, I was saying that membership and compliance often depend on the discretion and political will of individual states. For example, the United Nations Security Council exercises discretionary power in determining whether a situation constitutes a threat to international peace and security, leaving the room. Now we're going to illustrate the principle of voluntarism at the level of Security Council. So, as overview, guys, the Security Council is composed of 15 member states. 10 are elected non-permanent members, and 5 of these states are permanent, like Russia, United States of America, United Kingdom, China, and France. The role of the Security Council is to maintain international peace and security. In important matters, a vote of 9/15 is crucial in order to adopt a resolution, including the 5 permanent members. And this is really important here, because if any of these permanent countries, and I repeat, these permanent countries are Russia, United States of America, UK, China, and France. So if any of these permanent countries vote negatively, which means that it reserves her right in veto, the order or the resolution will not be considered or adopted anymore. And the abstention of permanent states is not considered as a veto. I mean here, if one of these permanent states doesn't vote, okay, this is not considered a negative vote. So let's have some examples. We have the Kosovo intervention in 1999. So in this case, guys, the Security Council operates under the principle of voluntarism, particularly in determining what constitutes a threat to international peace and security. Here, a striking example is the case of NATO's intervention in Kosovo in 1999. The Security Council here debated whether the situation in Kosovo warranted the authorization of force to prevent humanitarian crisis due to disagreements among its permanent members. So here, no resolution was passed explicitly authorizing the intervention. Also, NATO acted unilaterally, citing humanitarian reasons, while the Security Council chose not to declare this a violation of international peace. So, this situation underscores the discretionary power of the Council, as decisions require unanimity among permanent members, effectively granting them veto power, a manifestation of voluntarism in practice.
Sorry to
Okay.
interrupt you, ma'am, but I think your slide share has been stopped.
Okay,
I'm not
I will share
able
it.
to see the slide, ma'am.
All right, I will share it again.
Okay, ma'am. Okay, thank you.
Okay. Now, are you able to see my slide?
Yes,
Yes,
ma'am.
yes,
Now
ma'am.
I can see.
Okay, great.
Okay.
So moving forward, we're going to cover the Syria vetoes case. Here, the principle of voluntarism in the Security Council, guys, is starkly illustrated by the ongoing use of veto power. And this is concerning the Syrian conflict. Since 2011, Russia and China have repeatedly exercised the right to veto resolutions aimed at imposing sanctions on the Syrian government or authorizing military interventions. For instance, in October 2011, Russia and China blocked a resolution that sought to condemn Syria's response to civil unrest and impose targeted sanctions. They argued that such measures would undermine Syria's sovereignty, thus exercising voluntarism to align international actions with their own strategic interests. This scenario, guys, it is really important because it highlights how the veto system allows permanent members to prioritize their national policies over collective decisions, underscoring the voluntary nature of their commitment to specific resolutions. While this mechanism reflects the foundational principle of state sovereignty, it has also led to criticism regarding the effectiveness of the Council in addressing pressing humanitarian crises. So, this case illustrates how voluntarism operates as a double edged sword in international law. While it protects state sovereignty, it can also, on the other side, hinder the international community's ability to respond decisively to global challenges. Now, also another great example is the Gulf War 1990 and 1991. Okay. During the Gulf War, the Security Council passed resolutions to address Iraq's invasion of Kuwait, while the Council authorized military action under Resolution 678. It left the decision to individual member states to contribute forces. This highlights voluntarism here, as no state was obliged to participate in the coalition against Iraq. Each nation's involvement depends on its own consent and interest. So basically, guys, this is related to the political will of the member state. And also, this underscores the discretionary nature of Security Council resolutions, where states retain the choice to implement certain actions based on their own volition. Now, we're going to talk about a very, very great example here. Can you see the slide 7?
Yes, ma'am.
Okay, great. We're going to talk about the assassination of the Lebanese late Prime Minister in 2005 versus the assassination of the late Prime Minister of Pakistan in 2007. So if we have a look on the comparison and reflection of both cases, we can find that both cases, guys, underscore a key aspect of voluntarism: the discretionary power of states and international bodies to define their involvement in justice processes, while Lebanon allowed an international tribunal to take charge. Pakistan here restricted international engagement to technical assistance. So, this difference highlights a lack of uniform criteria in applying international law, where decisions are influenced by political alliances, state sovereignty, and global priorities. In the Hariri case, guys, um, it reveals the international community's discretionary power as the Security Council shaped the tribunal's scope. Meanwhile, in the Bhutto case, Pakistan's domestic discretion shaped the extent of international involvement. These consistencies or these inconsistencies challenge the credibility and universality of international legal frameworks. So, as a conclusion, we can conclude that both cases remind us that voluntarism and discretionary power are double-edged swords, guys. On the other hand, they protect state sovereignty, and on one hand, they expose the limitations of international justice when uniform criteria are absent. So, as we navigate an increasingly interconnected world, it is crucial to strike a balance between respecting sovereignty and ensuring accountability under international law. Only then we can build a fair and consistent global legal order. Now, we're going to talk about the International Court of Justice. Okay, guys, can you see the slide number 8?
Yes, ma'am.
Great. Now we're going to talk about the voluntarism, even at the level of the International Court of Justice. So, as overview for you to know, the role of the ICJ is to settle the dispute between states and only states under their agreement, okay? Which means that both states should recognize the jurisdiction of the court. So even at the level of the ICJ, we cannot sue a state without its consent. For the moment, we have approximately around 72 to 73 states are recognizing the jurisdiction of the court. Additionally, I want you to know that the decisions of the judgments of the ICJ are binding, guys. Binding means that these decisions are obligatory to all the United Nations state members, and especially for states in conflicts. Moreover, in case of no implementation of the decision of the judges, the winning party can report the matter to the Security Council, and then the Security Council will decide appropriate measures based on the voting procedure. So again, if one of these permanent countries vote negatively, so the decision won't be adopted anymore. So we have some great examples here. The Nicaragua versus the United States in 1986. Okay, in this case, guys, the ICJ's adherence to voluntarism is evident in the Nicaragua versus the United States case, because Nicaragua brought the United States to the ICJ, accusing it of violating international law by supporting contra rebels and mining Nicaraguan harbors. The United States here initially accepted the court's jurisdiction, but later withdrew it, claiming the ICJ lacked authority in the matter. The ICJ proceeded with the case and ruled against the United States, but enforcement of the decision was ultimately voluntary, because here the United States chose not to comply with the judgment, demonstrating that while the ICJ can issue rulings, enforcement depends on the state consent and cooperation, and underscoring voluntarism as a cornerstone of its operations. Also, another great example here is the nuclear weapons case in 1996. In this case, guys, the ICJ provided an advisory opinion on the legality of the threat or use of nuclear weapons upon the United Nations General Assembly's request. In this case, the ICJ's involvement was not binding. Okay, states voluntarily submitted arguments and accepted the non-compulsory nature of the advisory opinion. So this case, guys, demonstrates the ICJ's reliance on state consent for jurisdiction in non-contentious matter, and this reflects the voluntary character of international legal obligations under the court's advisory function. So both the Security Council and the ICJ operate within the framework of international voluntarism, which ensures that state sovereignty is respected. Take, for instance, the Gulf War. While the Security Council authorized collective action against Iraq, it left it to member states to decide whether to join the coalition forces. Similarly, in the ICJ's advisory opinion on nuclear weapons, states participated voluntarily, with the court providing a non-binding opinion. So these examples, guys, demonstrate the delicate balance between international cooperation and state autonomy, a hallmark of modern international law. So, brief, the principle of voluntarism is related to multiple factors here, guys. First, the accession to a treaty. So we cannot oblige any state to join a treaty. The power of permanent members. Again, if one of these permanent members vote negatively, the decision won't be adopted anymore. The qualification of the situation in order to take actions, and the ICJ procedures, which means how states can refer the case to the ICJ, and finally, the voluntarism at the level of the implementation judgments. Now, moving forward, we're going to talk about, okay, can you see slide number 9?
Yes, ma'am.
Great. Now we're going to talk about how can individuals be a subject of public international law. So we already saw how public international law plays a very important role in solving disputes between international organizations, and states. Now we're going to talk about how can individuals be a subject of the public international law. We have here different scenario. First, under international humanitarian law, I want you to know that this law, guys, is applicable during war crimes, like crimes against humanity, genocide. And when I say genocide, for example, is when attacking a church during a certain prayer, or even attacking a doctor graduation. So we have so many people. Also, crimes of aggression. We can consider Ukraine and Russia's war a crime of aggression. So here, when an individual is a victim of a gross violation of human rights, this one can submit a claim to Human Rights Council of the United Nations. And by doing so, the individual becomes a subject of international law. The second scenario is under international criminal law. I want you to know that the international criminal law is applicable when there is a systematic or generalized attacks, for example, attacking a specific sector, like the sector, the medical sectors, or any other sector. So here, the attack, guys, is systematic. Okay, so when a victim of an atrocity, or a witness, or a suspect, or an accused during the proceeding before international courts or any courts dealing with war crimes, these individuals are considered a subject of international law. Now, finally, we have international investors in case, and here, guys, we're in front of investment conflict. In case of a conflict between a foreigner investor and a country, okay, the investor here can submit a claim to the World Bank of the International Center of the Settlement for Investment Dispute, known by ICSID. I don't know if you ever heard about ICSID. And by submitting the claim, this investor becomes a subject of international law. So, as a conclusion, public international law plays an indispensable role in shaping global governance, fostering cooperation, and safeguarding human dignity. However, guys, its challenges such as reliance on voluntary participation and the absence of unified legal code highlight the need for ongoing efforts to strengthen its foundations and ensure its effectiveness in addressing contemporary issues. So finally, as we come to the end of today's webinar on public international law, I would like to take a moment to thank each of you for your time and attention. It has been a privilege to lead this discussion and share insights on the key principles and challenges within the field of international law. And I really hope the content presented today has sparked new ideas and provided valuable perspectives for your work and studies. Please, guys, feel free to reach out with any further questions or thoughts, and I encourage you to continue exploring with this important area of law. So thank you once again, Forensic Fusion team, Mr. Swapnil, Mr. Hassan, for having me. and I look forward to connecting with you all in future sessions.